Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. In less than 15 minutes we'll keep you abreast of the big commercial legal news stories. So grab a cup of tea, relax and allow us to keep you effortlessly updated with the information that your business can't afford to miss. First up, employment. Is obesity a disability? In a recent landmark European ruling, it has been held that obesity in some instances will be considered a disability and therefore subject to disability discrimination law. Regretfully, the European Court has not given precise rules when this will be the case, but it seems that if obesity restricts an individual's ability to actively and fully engage in their work, then it is likely to be considered a disability. This case has significant ramifications for employers. If obesity may be considered a disability, then employers in some circumstances will need to make appropriate adjustments for such staff. We'll keep an eye on developments in this area and of course keep you up to date. Remote working. Relocating to Australia would have previously meant finding a new job. But if your job allows for remote working, then why not work from the other side of the world? In a recent case, an employee had continued working for her UK employer after emigrating. All good so far, but when a dispute arises, does the relocation affect the employee's legal rights? The tribunal in this case gave an unequivocal no. This does not alter the employee's rights. The employee in this case was still entitled to bring her claim under the Employment Rights Act. Moving to the employment holiday pay saga. Following the decision in November last year requesting employers to include regular overtime in holiday pay calculations, concern has mounted about the risk of employers facing significant backdated claims. To restore business confidence, the government announced in December that it would make changes to the Employment Rights Act to limit backdated claims to a maximum of 2 years. Workers still, however, have 6 months to make claims as the changes will not apply until the 1st of July. The real effects of the government's announcements are, however, questionable, as the November ruling had already placed severe restrictions on the prospects of backdating claims. The majority of people under this ruling would be limited to a 12-month period in any event. Device fingerprinting. The European Data Protection Working Party is made up of representatives of 27 EU data protection authorities, including the UK's ICO, has published its opinion on device fingerprinting. Device fingerprinting works by collecting a number of pieces of information about a computer or other device. Although individually each piece of information is not unique or identifiable, the combination of all the different pieces of information can create a unique identifier. The practical effect is therefore similar or the same to using cookies that allow businesses to obtain information about visitors to their websites. Whether device fingerprinting is covered by the existing cookie laws is questionable. The view of the European Data Protection Working Party is that such online technologies do require an individual's consent before being placed on a person's electronic device. Covert surveillance on an employee. Caerphilly Council has been warned by the ICO about its conduct after carrying out covert surveillance on an employee. The surveillance had been authorised on anecdotal evidence and began only 4 weeks into the employee's sickness absence. No other measures were taken to discuss the employee's absence. The ICO has re-emphasised its view that covert surveillance should only be used as the last resort and when less intrusive alternatives have first been considered and determined as not appropriate. The ICO's website has guidance on the circumstances when it is appropriate to monitor employees at work. From the end of January, new regulations were effective to consolidate the rules relating to the naming of companies, limited liability partnerships and trading disclosures. The changes include the list of characters that can be used in a company name has been extended. Currently, businesses can only pick from the Roman alphabet and a few additional characters. The rules concerning how to deal with company names which may be considered the same have been changed, e.g. Stone Company Limited will now be treated the same as Stone and Company Limited. And the list of words and expressions to be ignored when considering whether the names are the same has been reduced. The terms export, group, imports and international have all been removed. And if 6 or more companies operate from one location, they will no longer have to display the company name at all times. Instead, they can be shown in rotation, like digitally, or be available for inspection. In a separate set of regulations also enforced from the 31st of January, a revised list of names that the Secretary of State must approve for use in a company or LLP name. 26 words have been removed from the list, including European, International and United Kingdom. So these words can now be used without first obtaining permission. The judgment in the battle between Europcar and Enterprise over the use of the letter E was handed down in January. The facts, briefly, are that Enterprise have been using a stylised E as a logo since 1969, and in 2012, Europcar also started using a stylised E, albeit in a different font but with similar green colours. Enterprise commenced proceedings against Europcar for trademark infringement and passing off. Enterprise's claim was slightly hampered by some of its trademarks being subject to cancellation proceedings, and was therefore forced to focus on the infringement of its community trademark, which was registered in black and white. Nevertheless, the court found in favour of Enterprise, following some significant evidence that consumers had been confused by the two brands. This case does not make new law, but re-emphasises that the risk of confusion will be key in determining whether a case for trademark and/or passing off will be successful. For businesses, it is a good reminder of the importance of taking a cautious approach when there is a risk of brand confusion. Those that were well acquainted with the brands would not have been confused, but of course the true test in most cases will be whether the general public are confused. Copywatch. Many companies are unaware of the need for a copyright licence for actions such as making copies of press cuttings. To increase awareness, the Copyright Licensing Agency has launched a redesigned website for its compliance arm, Copywatch. The redesign aims to make it easier for licensees to understand compliance in the workplace by providing both employers and employees with information that allows them to make informed decisions about copyright licenses. Interestingly, it also includes a simple form for employees to report when their employers breach copyright law. The High Court held in a recent case that the parties had settled their litigation by an agreement contained in an exchange of emails. Although the settlement agreed by the parties contemplated that a court order would be filed at court, the judge found that the settlement was not conditional upon the formal court order. This case is a clear reminder of the need to include appropriate words, e.g. subject to contract, if you do not wish to be bound by the correspondence. Disclosure of conflicts of interest. The upper tribunal has rejected an appeal by a non-executive director who failed to declare a conflict of interest. The Financial Conduct Authority, the FCA, imposed a financial penalty of £154,800 and made a prohibition order. These sanctions were based on the FCA's findings that she had misused her non-executive director position, advanced her own commercial interests, and failed to disclose a conflict of interest. The case emphasises the need for directors to make regular, up-to-date declarations of interest and the increased regulatory burden on directors, particularly in the financial services sectors. The FCA has announced a new consultation on proposals to limit the sales of gap insurance when it is sold as an ancillary product. Typically, gap insurance is sold at the point of sale of a motor vehicle. There have been concerns that often the consumers do not have sufficient information to make an informed decision at that point. The FCA's market study in 2014 found that consumers were often buying gap insurance without having previously thought about the product or considered alternatives, and therefore were not always getting the best deal. The FCA's key proposals are to require any businesses selling gap as an ancillary product to encourage customers to shop around and to introduce a deferred opt-in or pause in the sale. A dealership salesperson can start the sales process but can't conclude the sale for a set period of time, giving customers the time to consider whether they need the product at all and perhaps to shop around if they do. The FCA has requested feedback by the 13th of March and has advised that it plans for the new rules to be effective from September. The Serious Fraud Office obtained its first convictions under the Bribery Act on the 5th of December. Sentences of 28 years in total were imposed on 3 men. 2 of those accused were convicted of offences under the Bribery Act. The offences followed an investigation by the SFO into Sustainable Agro Energy plc. These are not the first Bribery Act convictions. Previous prosecutions have related to relatively minor activity, including the conviction of a magistrate's court clerk who took a £500 bribe to remove a speeding conviction from a court record, and the conviction of a Chinese student who tried to bribe his university professor. The prosecution in this case followed an investigation into offences that took place between April 2011 and February 2012. The defendants were found to have been involved in a pension investor scam where people were encouraged to invest in a biofuel scheme that was supposed to yield huge returns. The scheme was a sham and investors were defrauded of around 23 million. There are some interesting points to note from this case. Firstly, the speed which the case was processed. These men were charged relatively recently on the 14th of August 2013. And the fact that both the bribe payer and the bribe receiver were prosecuted under the Bribery Act is proof that it's no longer better to give than receive a bribe. And the fact that the SFO will take on bribery cases with an international element. This case had a Swiss bank accounts, foreign companies and misrepresentations about land in Cambodia. And finally, the fact that the prosecution was successful. Bribery corruption cases have been notoriously difficult to prosecute in the UK and abroad. Thank you for joining us for this month's Commercial Legal Bulletin. There is also a podcast or downloadable PDF of this newscast available. We hope you found this bulletin informative and would welcome your comments, good or bad. Please don't forget to share this with your colleagues. The website details of Radius Law and LexisNexis will be shown on your screen shortly. We'll be back next month with another update. Until then, thank you and goodbye.